Thanks very much, and kia ora koutou. My name is Vernon Rive. Today I'm appearing with my barrister hat on, but I'm also a senior lecturer in law. Years ago, when my colleagues and I at Chapman Tripp were asked to look at some of the legal aspects of a nutrient trading scheme that was being developed by Motu for the Rotorua Lakes. It was back in the heady days of 2008. Can you take yourself back there? The last year of the Labour government. Kevin Rudd at the helm in Australia. G.W. Bush in the last few years of his presidency in the United States. An unknown Justin Bieber singing sweetly to 25 people in his church not yet discovered on YouTube. And at that stage, I guess the idea of a tradable nutrient discharge permit scheme was regarded as distinctly avant-garde. At that time, the Lake Taupō nitrogen trading scheme was still winding up for a marathon Environment Court hearing. The New Zealand carbon emissions trading scheme was still in its infancy, or in fact fighting for survival. But looking back at things from a 2012 perspective, I think it's fair to say that we've come a long way. As you'll hear from Justine and Sandra in a moment, the Lake Taupō scheme is now up and running. It received Judge Whiting's stamp of approval. Trading has started, I'm told. The New Zealand carbon emissions trading scheme is operational. Across the ditch, our Australian friends are dipping their toes in the water of a carbon tax designed to morph into an emissions trading scheme later on. We heard from Nikki that other aspects of market mechanisms for environmental issues in New Zealand are also taking hold, including in the air quality area. So, in short, the use of market instruments for environmental challenges is, if not exactly mainstream now, then at least not quite the novelty that it once was. So over the next few minutes or so, I'd like to talk about some of the legal work that I and the team at Chapman Tripp did on this nutrient trading scheme. I'm not going to try and compact 4 years of work into 15 minutes, but I would like to touch on some key points from a legal perspective. One of the first issues that we had to look at, and that I'll talk about very briefly, is whether it's even possible to get a nutrient trading scheme up and running under the RMA in its present form. Now, Motu asked us to look at that not because Motu is not interested in reform, but because I guess it's acutely aware that reform can take a while, and there's a valid point to be made about working with what you got. Susie mentioned the importance of compliance, and we also heard from Hugh on that, and so I'll talk a little bit about compliance, the tools available under the RMA in its current form for compliance, and also whether some other models might be useful as well. I'll talk briefly about some comparisons between the Lake Rotorua model that Motu have been working on and the Lake Taupō one, and then I'll offer some conclusions. So, as I said, one of the first legal issues that we looked at was whether it's possible to get a nutrient trading scheme up and running under the RMA in its present form. The 2008 opinion by Chapman Tripp is on the website, the Motu website, and that goes into some detail explaining the reasoning supporting our conclusion that, in theory, a nutrient trading scheme could be provided for under a regional plan change. The subsequent Environment Court decision of Judge Whiting on Variation 5 in Taupō has confirmed aspects of that, although there are some differences between the Motu scheme and the Lake Taupō scheme. One of the key early issues that we had to look at was to identify what would be the most appropriate basic legal building block for a nutrient trading scheme. And here there were two options that we were mainly looking at. Would it be appropriate to base the scheme around a system of discharge permits or a system of land use permits? And there were pros and cons for either. Many of you, I'm sure, will be aware that under the Resource Management Act, Section 15 makes it an offence to discharge contaminants to land in circumstances where they will reach water unless it's permitted activity under a regional plan or authorised by a resource consent. And so I guess the idea of a system which was based on regional consents had some intuitive appeal. It's superficially more logical, perhaps, because the scheme is about managing and reducing discharges of nutrients to land and water. But there are some fishhooks with a scheme that is based on Section 15 discharge consents. one point, not a fishhook so much as an observation, is that nutrient discharges are a result of land use activities, which suggests perhaps that land use is what should be focused on. There's also the issue that regulating land use activities is a more direct way of managing the consequential discharges. Perhaps importantly as well, recent history, and in particular I'm talking about variation 5 in the Lake Taupo nitrogen trading scheme, suggests that there might be opposition to a scheme based on Section 15 discharge permits. And the issue that I'm touching on here in particular is concern from some areas that a scheme which assumes that, for example, pastoral farming, dairy farming, results in illegal discharges to land unless they're specifically authorised by a regional plan or a district or a resource consent, would create significant precedent issues around New Zealand. I quote from the lawyer for Federated Farmers in the Variation 5 hearing, who told the court that a finding in that case that pastoral farming as a discharge activity would have significant implications for regional councils. It would effectively be a finding that a farmer with stock on his or her land doesn't hold a discharge permit, is in breach of Section 15 of the Act and risks prosecution. Now that was, the opposite point was argued by the lawyers for the Regional Council, and ultimately Judge Whiting, perhaps with the wisdom of Solomon, decided that it wasn't necessary to resolve this contentious issue about whether pastoral farming results in illegal discharges to land per se. Rather, he said that from a strict legal perspective, there's nothing wrong with a scheme which assumes that discharge consents might be part of it, but otherwise he left that battle to be fought for another day. So what we've got with the Lake Taupo scheme is kind of a hybrid system. It's mainly based on land use consents, but discharge consents are provided as permitted activities out of an abundance of caution, I guess. And you can talk to the people more closely involved with the Lake Taupo scheme if you want some more details on that.